Okay, hi everyone. I'm going to pursue on what Maxine and Barb said and present other parts of what we're trying to do in that book. And I want to say, and I'm going to speak, I think, for Maxine and I, it was really a great pleasure and honor to work on this manuscript and really to, I guess, to work on the legacy of Barb and Catherine, because this is really the result of 10 years of work. I've had the great pleasure to work with that team, and I've learned a lot, and I'm very grateful. Thank you again, Barb, for taking us on. So I'm going to start by saying, I'm going to use my clicker, and I want to thank also the interpreters, because I think it is a psychosocial risk to interpret how I talk in a conference. So thank you so much for your invisible and yet very visible work. So the one thing I have to say is that when we think of mobile work and regulatory challenges in terms of occupational health and safety, we have to understand that the regulatory landscape is a fissured one. So yes, we know we have multiple regimes according to the provinces, but that's not only the point. There's the occupational health and safety regulatory requirements, but you also have public health officials that will kick in some provinces, but also the importance of employment standards. That's another set of regulation, but will also have an important impact in terms of occupational health and safety. So that's part of the background I want you to have in head when I'm going to go through my presentation. So yet again, and this, Catherine and David Walters worked on this from an occupational health and safety perspective. HOSH more and more perceives itself as a process-based regulatory standard over a more traditional prescriptive standard. So it's really the idea that we're leaning more and more towards an overarching principles that we require general duties from the employer, and that should really allow for occupational health and safety regulatory frameworks to grasp the changing nature of work. But what we've come to see in all this work that's been done by a lot of colleagues that are also in this room right now is that for mobile workers, it's not tailored to them. These general principles cannot grasp their reality. The work of the inspectorate and several institutions do not grasp the reality and that leads to issues of effectiveness. The same goes for compensation regimes. As you know, there's this general idea of what happens in the course of the employment will be compensated by workers' comp. Well, for mobile workers and the various categories of mobile workers, and Maxine's going to touch on this after, it's a real issue to conceive and conceptualize what happens when and what's in the course of the employment. So in terms of occupational health and safety, the first thing that we have to say is that mobile workers face a broad range of physical, chemical, biological, ergonomic, and psychosocial hazards. That's pretty much obvious probably for all of you. But what we have to also understand is that these workers face very specific risks that are very, very hard to grasp from a regulatory perspective. And not only that, very different from one province to the other. So when we think of road conditions, so we live in Canada, we have road conditions that can happen to be very, very dangerous at some moments. How do we regulate the state of the vehicle? So these two examples, if you take one province to the next, will be regulated in a very different fashion. So who does the road belong to will have a consequence. In some cases, the road will belong to the employer if we're talking about remote areas, and that's going to have specific consequences in terms of occupational health and safety. Now, the requirements will vary, and when we think of workers that go from one province to the other, fly in, fly out, drive in, drive outs, bus in, bus outs, and other categories of workers, they have to understand the regulatory requirements that will vary from one province to the other. The second issue, and this is an issue I've worked on quite a lot in the past few years, is the issue of long hours and fatigue, and the fundamental issue of working time. And how do we define in the Canadian context and the different provinces, what's working time? When are we working? Effective work is working time, but what when you're commuting, when you're bussing in, bussing out, when you're waiting maybe for an assignment from the employment, are you effectively working or not? And that determination will have an impact on the number of hours that you're actually working and the fatigue that will entail. And of course, important hazard entails to that also. So one main issue here, and when we think of the idea of a fissured regulatory landscape, is the fact that the general duty of preventing occupational health and safety for the employer for working time is very, very linked. And really think about that in all the jurisdictions you work in to employment standards and the way we conceive working time as paid work. So basically, you're working, you're paid when you're working, but you're only paid when you're effectively working. And the very fuzzy boundaries before you're working and after you're working is generally not considered to be working time and won't be considered as an occupational risk in most cases. And that's a whole big issue for several categories of mobile workers. Okay, so the other big issue for several mobile workers is that they will often be working in remote or isolated workplaces. Different sectors can be thought of, but also farm workers in often cases, not necessarily geographically remote for an urban center, but will be highly isolated from larger city centers. And this can have an impact on how fast can emergency vehicles get to them if they actually get injured. And this specific issue, when we really delved into that for the book, was super interesting to see how it was conceived differently from one province to the other. So in Quebec, you'll have to have specific requirements if you're in a remote area, if you hire more than 25 workers. Now, in Alberta, for instance, you'll have more general rules that would apply for an emergency situations for a remoteness. And in Ontario, you'll have specific rules for offshore and oil and gas workers. So again, imagine the worker that's mobile across Canada and trying to understand the spectrum of protections that apply to him if he's working in a remote workplace, the variegated protections from one province to the other is in itself, in our perspective at least, an issue of effectiveness. The other thing is that in often cases, mobile workers will be living at work, will not be living at home, but will be temporarily living at work. And that's another fuzzy boundary, a regulatory fuzzy boundary. So give you, again, a couple of examples. We go through a couple of provinces in the book, but in Quebec, we have specific regulations that apply to industrial camps. Now, when COVID hit in Quebec, a lot of you know about that. A lot of people said, who's responsible for temporary migrant workers that live in that the employer provides for employment? Is it the labor inspectorate? Is it public health officials? Is it no one? So again, because the regulatory requirements were really specific to one group of workers that worked in industrial camps, other groups of workers that lived at work were completely flushed away from the span of intervention of the labor inspectorate. The same goes, I'll give the example of Ontario and Alberta, where it's conceived more like a public health issue. And then again, another set of institutions and actors come into play that don't have the same regulatory background or the same overarching principles that the authorities that are in charge of implementing occupational health and safety. How many minutes do I have left? Yeah, I'm doing good. Another issue, usually, and that's not the case. I usually go like Barb flicking around my PowerPoint. So the other issue that we came across in this research, and again, a lot of that done by a lot of you, is when no housing is provided. So there's a real risk if the employer is not providing housing, is not required to provide housing, and we're in a housing crisis, as you know, in several places in Canada. Where will these workers lodge? Where will these workers actually live for the time of the employment? And in often cases, they will be confronted to unsafe housing. Yet again, is the employer responsible for this? Who's responsible for that reality? Well, that housing is intertwined with the employment context. Okay. So I'm going to go fast on this. Of course, in the book, we discuss a lot of the additional layers of vulnerabilities that mobile workers compose with. Barb touched on that. Maybe a couple of examples that we really try to describe in the book. So obviously the isolation and separation from family and community. And what's extremely interesting is that what can help this is effective access to communication means. But effective access to communication means is not available everywhere, or for everyone. So that's another issue that can come into play, is that the communication can theoretically exist, but is it fully accessible for all groups of workers? The second element, which obviously can be an additional layer of vulnerability, are the divides between the permanent groups of workers and the temporary temporary group of workers. Obviously, this goes for international migrant workers, but also for workers that will be there temporarily on the fly-in, fly-out, drive-in, dry-out model, where they'll be there for a subcontractor for a definite period of time and will coexist with other groups of workers that are there on a more permanent basis. That can in itself also constitute a layer of vulnerability for these workers. So we've discussed this in other sessions, and I'll talk about it a little later today, but the specific issues that pregnant or workers with disabilities face, and this is super interesting when we think of how the duty to accommodate, which has been crystallized by the Supreme Court of Canada a couple of years ago, is completely unevenly applied from one jurisdiction to the other, where it's supposed to be an overarching principle that governs not only workers' comp, but also occupational health and safety. The gendered aspects and conditions of mobilities for those who go, but also for those who stay. To who are we transferring our labor of care when we are gone working is a central issue that can also contribute other layers of vulnerability. So I'm going to go really fast on compensation schemes because Maxine is going to touch on this. So I'm just going to talk about one thing that really struck me in the past couple of days are the interjurisdictional and international agreements. So these agreements, so there's in Canada, maybe some of you know, I didn't know before doing this research, but we have an interjurisdictional agreement that most worker compensation board are part of. So Quebec is part of it, but withdrew for occupational diseases, but most provinces are part of this. So it's basically workers' compensation boards that can kind of work together when a worker is in a condition of interprovincial mobility. Now, it's super interesting because we didn't find any research that documented the effect of this agreement. Is it just a document or is it effectively applied? The same goes for international agreements. In Quebec, we have 15 international agreements, but with only European countries. In Ontario, so I'm giving you just a few examples, but we stated all of them in the book. In Ontario, there's 3 international agreements with European countries, but in Ontario, and that's interesting, and I'd like to know if there's research or community knowledge on this in terms of the special agreement with some seasonal agricultural worker program countries and Canada in terms of international agreements when a worker is actually injured. So this, for me, is there's a policy issue here, but it's also a research question as what do these agreements actually do? Do they provide, do they yield any results? Or is it just basically something, an administrative document that doesn't yield any effective results? So I'm going to conclude very rapidly by saying that I think this is something that's really laid out by all the work that's been done in On the Move, but the mobile workforce is not unique. It's multifaceted, and sometimes there's overlapping issues that can come one on top of the other. Think of international migrant workers that will be housed at the employers in often cases, and will often have to also drive around the working place and confront different hazards there linked to the state of the vehicle, the conditions of the road. So the idea of the mobile workforce as being a very fragmented group also in itself, and to understand the different issues that overlap, that the overlap in itself is a challenge to regulatory effectiveness. So just a few words, and we do have a chapter, Barb said it in the book on COVID, but for me, COVID for mobile worker was a real-time social laboratory. Just think of truckers. Truckers, their working time is regulated by Transport Canada. Well, maybe you all know that during COVID, Transport Canada suspended its regulation on the number of hours that truckers could ride in 1 week because they had to rush stuff from one coast to the other. So there was no more limits for a very long period of time on how many hours truckers could actually work. So in itself, in terms of experimentation and regulatory experimentation, for the worst, sometimes for the better, COVID for me is still a very interesting social laboratory. So I think we've said this a lot. We often state that psychosocial risks are a wicked problem. And I think that mobility, thought of in an occupational health and safety, is also a wicked problem, multi-pronged, that needs several disciplines to discuss to see what are the best arrangements in terms of regulatory effectiveness. Thank you.